Hi, it's Shan Wu with an under color of law hot take on the upcoming witness testimony in the Donald Trump trial that we've all been waiting for, which is Michael Cohen. Now, this is the election interference case, which is based on Trump's alleged falsification of business records to hide the fact that actress and director Stormy Daniels had been paid to stay quiet about their alleged affair. And recall, she got paid by Trump's attorney and fixer, Michael Cohen, and that payment was done with the intent to interfere with the election. Meaning, the Trump campaign and Trump didn't want this information to come out on the heels of the infamous Access Hollywood tape, where he bragged about grabbing women by their genitals without their consent. Now, this past week, we've been hearing some what they call foundational witnesses. And everyone is looking ahead to the possible testimony of Karen McDougal. That was a model that Trump allegedly had a long-term affair with. And she was also paid money to stay silent under the National Enquirer's so-called catch and kill scheme. And we may be hearing from Stormy Daniels herself. But almost certainly, we are going to hear from Michael Cohen, who is Trump's lawyer and fixer. Now, there's been a lot of commentary done about just how important Cohen's testimony is going to be. So I want to take a look at some of the criticism and the predictions about how he'll come across to the jury and give you my reaction on it and also my take on how you can view it and think about the way the prosecution is setting up this important testimony. So to start with, we have to remember this is really a paper case. Cohen's testimony is being corroborated by the money trail, and that's why earlier this week you had Cohen's banker take the stand to talk exactly about how Cohen was trying to come up with the money to pay Stormy Daniels and laying the evidentiary foundation for getting those records into evidence and for what Cohen is going to say about those records. Also on the stand was Keith Davidson, a lawyer who had represented both Karen McDougal and Stormy Daniels. That was Davidson's sort of niche practice, was representing celebrities and getting them to be paid by organizations like the National Enquirer. Davidson talked about his long struggle to get Michael Cohen to pay. Now, earlier, there'd been testimony from the National Enquirer publisher, former publisher, David Pecker, who indicated that after they had paid $150,000 to Karen McDougal under this catch and kill scheme, the Enquirer and Pecker got kind of tired of being what Pecker described as being a bank. And so in the Stormy Daniels case, they seemed reluctant to fork over the money. And that's what put Michael Cohen in the situation of having to figure out how to come up with the money himself to make the payment. So Davidson's testimony made it quite clear that Cohen was quite desperate to put off having to pay. Eventually, Cohen used a home equity loan on his own home to make the payment, or rather to front the payment before he sought reimbursement. At other times, Cohen even was trying to just push the entire matter off until after the election, because at that point, likely they would have felt there was no need to cough up the money because the election was already over. But when he did front that money, he got reimbursed for it. And that's the basis for the falsification of business records, because they naturally didn't put down the real purpose of what the money was for. They basically falsified the records, disguising it as maybe invoices for Cohen's legal services, rather than the fact that it was a so-called hush money payment to keep Stormy Daniels from talking about her relationship with Trump. Now, again, there's nothing illegal about making that payment to her. One can have a contract, non-disclosure agreements, but the illegality is falsifying what it was, and in this case, falsifying what it was for the reason, with the intent to commit the campaign finance violation. That's the illegality. Now, during Davidson's testimony, it was clear that he was greatly irritated with Cohen, greatly frustrated with trying to get the money on behalf of his clients. Now, take a listen here to what one prominent defense lawyer's take on Davidson's testimony was, meaning what can Davidson's testimony tell us about how Michael Cohen will help or not help the prosecution, and maybe how Cohen will be viewed by the jury. This is Bill Brennan, a well-known defense counsel who actually had represented the Trump Payroll Corporation back in 2022 in a criminal case before the very same judge listening to this case, presiding over it, Judge Juan Merchan in New York. So take a listen, and I'll give you my reaction on the other side.
And Jake, you astutely point out, it's not enough. Maybe, woulda, shoulda, coulda. It's beyond a reasonable doubt. It's the highest standard of proof in the history of jurisprudence. They have the burden. That burden never shifts to the defendant in any case. And the way they cobbled this case together to get this felony in there, they tied it to, he had to do these things in furtherance of another crime. And that's where I think they may fail.
Now, the first thing that's wrong with this take is Brennan saying that the case is cobbled together. I'm not actually sure what he means by that. It's not cobbled together any more than any case is something that you have to put together with facts and evidence and witnesses. The narrative that they're putting together here is one, as we've discussed, that the business records were falsified with the intent to commit the election crimes violation. Now, there are a lot of commentators who feel that there's something wrong with using the election crimes violation, but there's not. If you hear anyone say that this is a newfangled theory or it's one that hasn't been tried before, just remember that the Manhattan District Attorney's Office has used this misdemeanor crime of falsifying business records in conjunction with the intent to commit all sorts of different other felonies some 10,000 times. So it's hardly a very novel theory. Now, the point that Mr. Brennan makes about this very high standard of proof beyond a reasonable doubt, that's interesting. That's a very standard argument, and it's true. It is beyond a reasonable doubt. But it's a standard argument that defense counsel often use when they don't have too much else to argue about. So they're absolutely right. That is the highest standard in law. But whenever you hear a defense lawyer really relying upon that standard, it often means they don't have any theme to their defense, and they don't have any great attacks or really good ideas for poking holes in the prosecution's case. Now, Brennan's obviously disparaging the credibility of Cohen based on some of Davidson's testimony. And as we have learned, Davidson had been kind of frustrated with Cohen, and his testimony reflected his frustration at that time. But take a listen to this reaction to CNN anchor Jake Tapper's question.
Hush money cover-up trial is underway in New York right now. The former lawyer for both Karen McDougal and Stormy Daniels just left the stand. He had been testifying about his efforts to secure the payment from Trump lawyer and fixer Michael Cohen to Stormy Daniels in exchange for the rights to her story, her allegations of a brief romantic interlude with Donald Trump. The jury has just been excused. And Bill Brennan, former attorney for Trump payroll, this is interesting because this was the prosecution talking about this information. And one of the things, it's Judge Merchan just told the jury he's going to see them Thursday morning at 10 a.m. A gag order hearing is scheduled that morning for 9:30 a.m. So that's 9:30 a.m. for more Trump alleged violations of the gag order Thursday morning at 9:30. And then at 10 a.m., the trial will begin, and Judge Merchan is off the bench. Court breaks for the day. In any case, so Keith Davidson is the lawyer. He's trying to get money for Stormy Daniels. And one of the things that's interesting is he keeps telling, he has doubts in Michael Cohen's integrity. I think it's fair to say.
Wow. Shocker.
So
breaking news.
At one point, they're trying to get this money, and David Pecker and Dylan Howard and all the fine folks from the National Enquirer tabloid kingdom are not going to pay it because they've already paid it to Karen McDougal. They thought they were going to get repaid. They were not repaid. They're like, okay, Michael Cohen, you're on your own here. And what's interesting is...
So the problem with trying to take away from Davidson's frustrations with Cohen, or even Davidson having doubts about Cohen's integrity, doubts about his credibility, doubts about his reliability, is it's apples and oranges from what the jury is considering in this context. It's going to be crystal clear, as it already has been made crystal clear, why Davidson was frustrated. He was getting stiffed. He wanted Cohen to pay him, and the payment wasn't coming through. The jury's not getting stiffed by Cohen. They're not going to be feeling frustrated with him about that. They will simply be listening to why Davidson had been frustrated, which they've heard, and thinking about what Cohen's telling them. They're not really going to say, oh, if Davidson was frustrated with him for not getting paid, we should also be frustrated with him. You should also doubt his word. It's apples and oranges. Davidson was frustrated because he was trying to get his clients paid, but the payment was being delayed. There were even times when it seemed as though the payment might be delayed past the actual election. There was testimony about Cohen saying his guy, meaning Trump, was in 5 states campaigning that day, so he couldn't get a hold of him. Importantly, why would he need to get a hold of him? To get the approval or to get the money. A critical point, because one of the most important aspects of Cohen's testimony is going to be that nexus to Trump himself, that Trump knew about the plan, knew about the payment, and even had to authorize it. So that's a really critical point to it. So it's easy to understand why Davidson was feeling so frustrated at this point. I mean, the idea that it might even get delayed, the payment for his client, until after the election probably made it seem to him that it was likely the client would never get paid. Also remember, the testimony is that Davidson's being paid on what's called a contingency fee, meaning he gets a portion of the payment to his client. It's kind of like the personal injury cases, or there's a car accident. You hear those advertisements say, your lawyer only gets paid if you get paid. Now, he had a pretty decent deal. He had a 45% contingency fee, which is really right on the edges of what the ethics rules allow you. Ethics rules don't like deals where the client gets paid and the attorney takes 80% of that. The majority needs to go to the client under legal ethics rules. He's right on the edge there with a 45% contingency fee. But because it's contingent on his client getting paid, he was pretty frustrated. He was really pushing Cohen to get him paid, and he felt that Cohen was stiffing him. He no longer trusted Cohen. He thought Cohen was lying to him. But here's the point. What Davidson thought about Cohen at that point in time is what he thought about Cohen at that point in time, and is part of the narrative about the back and forth that was going on. So don't let commentators confuse you, just as the defense is going to try and confuse the jury with this idea of, because somebody like Davidson said that Cohen wasn't trustworthy at that time, he was lying to him about getting paid, that means that Cohen's testimony now can't be trusted. Cohen's testifying now, or will be, about what historically had happened, what he was doing, what the paper trail shows. That's apples and oranges about people's opinion about Cohen at the time that they were having these interactions. So let's go to Brennan again, the defense counsel, who is putting out some more defense counsel standard arguments about the strength of the case and how he sees Cohen as actually being the weak link in the case. And take a listen.
He'd do it on his own.
Yeah.
Okay. You said earlier, Jake, all of this testimony between these 3 guys leads to confusion, and confusion leads to doubt, and doubt leads to acquittal. And that they better get it together, because this is a guy who said, I'd take a bullet for Trump. This is a sycophant. This is a barnacle. This is a guy who's attached his star to Trump's wagon at this time. And then he takes a home equity loan on his residence, doesn't tell his wife. Nobody trusts him. And he's earned that distinction. If this was so important to President Trump, why wasn't he involved? Why is Cohen running the show? Cohen wants a pat on the head. Good job, good job, good job there, Michael Cohen. That's what he's looking for. And when the jury can't trust Cohen, like Davidson can't trust him, one or more of the jurors will not convict.
But the jury is not going to be in the position that Davidson was in. They haven't been repeatedly stiffed by the guys. It's a totally different question of credibility.
Right. But this is what the defense is going to say.
Oh, wait till they get a load of this guy on the stand for 3 or 4 days.
And this is what the prosecution is going to say. And you out there, our beautiful viewers, you are the jury in your living room or your kitchen or your office, and you can decide how you would react to those arguments.
So the problem with this defense idea The problem being a criticism of Cohen for being an extremely loyal, almost servant type of mentality. He just wanted to please Trump. Problem is that's not really a weakness in the prosecution. It actually helps the prosecution. It doesn't hurt the prosecution because it supplies the exact motivation as to why Cohen was doing everything in his ability, even taking out a personal loan on his own house to help his boss. It shows how motivated Cohen really is to help in this crime on behalf of Trump. It does not show some other innocent motivation that would defeat this intent to commit the election interference part of the crime. Also, there's the point made by Mr. Brennan, the defense counsel, which was, if this is such an important issue for Trump, why didn't Trump do it himself? That's kind of silly. I mean, it's exactly because it was so important and so illegal that Trump is not going to soil his own hands doing it. There's a lot of analogies made to, crime, mafia cases, which I think is a little bit overdone about the Trump trial. But if you do use that rough analogy, obviously, the mafia boss, the kingpin, is not going to go and do stuff himself. He has other people do it. Cohen's going to lean pretty heavily into this analogy. I mean, he constantly makes the point that Trump would try to adopt sort of like a Goodfellas kind of routine where they talked in code, everybody understood things. That's something that Cohen's really going to lean into, but it makes common sense that when you're the head of something, if you think something's questionable, you want to have some insulation between you and the actual deed. Also, just some common sense. I mean, if you think about Trump actually making the payment himself, one has to speculate, when's the last time Trump actually broke the rust off his wallet and paid for something himself? Now, tangent, I do believe that in a previous interview Karen McDougal had with Anderson Cooper on CNN, that she said that after the first time she had sexual romantic relations with Trump, that he offered to pay her. And that she had told Trump she was not that kind of girl. Trump said something along the lines of, oh, you're very sweet or something like that. And according to McDougal, they actually had a rather longer term relationship. But I digress. As we get closer to hearing from Cohen himself, it's going to be important to keep in mind just how the prosecution is teeing up this critical testimony. Now, they've made what I think is a very traditional choice to save the most important, most powerful witness for last. They've done these sort of foundational witnesses, getting the evidence in, giving the context, and then they'll put on Cohen. Now, doing it that way is very good for the jury's interest and their understanding, because they've learned all the context, all the detail they need to put Cohen's testimony in context. Some of that testimony can be kind of boring. I mean, if you're just listening to a banker or records custodian explain, yes, this really is the records, but it's really necessary in order for the case to have the right context and the foundation established. Might also account for why Trump's having some trouble keeping his eyes open, because that kind of stuff, isn't too riveting for him to listen to. But having Cohen go last, setting the stage that way, of course, puts an enormous burden on Cohen's testimony. All the attention will be on that. In that sense, for those of you who know a little bit about first-year law school, it's where your entire grade is based on your final exam. So you can do nothing the entire year, analogy trial, and it all comes down to that one exam for 100% of your grade. That's one way to think about it. But that's actually not what's happening here. Because all this foundation that the prosecution has been laying already corroborates so much of what Cohen is going to testify about that what he is doing is simply bringing to life the facts and the evidence that the jury has already heard. He'll be talking about the paper records, the money trail that's already been introduced. And a really good way to think about this is there is a critical issue for Cohen to do. He's got to supply the nexus to Trump. But what the prosecution is doing is giving the jury a really small target regarding Cohen's credibility. And his credibility is so important. But what you want to do as a prosecutor is to make the particular testimony and evidence that the jury has to consider in your star witness's credibility, very focused and a very small target, making it a really hard target to hit for the defense. So the prosecution's teeing up the jury to have what they hope will be overwhelming evidence of everything Cohen did and why he did it, corroborated by evidence not dependent upon Cohen's testimony himself. Objective evidence, paper trails, money, other witnesses, is already going to establish what he did. What's left is going to be the single point of whether Cohen is telling the truth about his interactions with Trump and Trump's knowledge. That's the critical connective tissue that Cohen needs to supply for the prosecution. And if the prosecution succeeds in teeing this up the right way, then when the defense tries to discredit Cohen, the jury actually is faced with a tough decision. In order to discredit him, they'll have to buy the defense argument that Cohen did all this on his own. He came up with the idea to pay the money. He went rogue without Trump knowing about it. And the prosecution is going to ask the jury, why would Michael Cohen do all that? Michael Cohen wasn't the one who was having alleged sexual romantic relationships with Karen McDougal or Stormy Daniels. He wasn't the one running for president. That's going to make it a very difficult decision for the jury to reject Cohen's testimony, because common sense is going to tell them, why would he be doing this? Why would he be going rogue? Why is the case all about Michael Cohen? The context and the way the evidence is going to make that a hard target, a small target for the defense to hit. So as we look forward to the rest of the case and Cohen's likely testimony, keep that in mind, because you're going to be hearing a lot of speculation about how he's going to perform on the stand. So that's it for now. I'm Shan Wu. This has been an Under Color of Law hot take on waiting for Michael Cohen. Thanks for all the comments again. Really love getting your feedback and try to respond to as many as I can, and looking forward to talking to you again soon.
Love this video? Make sure you stay up to date on the latest breaking news and all things Midas by signing up to the MeidasTouch newsletter at MeidasTouch.com/newsletter.